Good evening to everyone. This is Judge Volkman. I'm the presiding judge in Santa Cruz County. I've been a judge for 14 years. I've been a judge in relationship to this competition for 14 years, and for about 10 years prior to that, I was a scoring attorney. I think it is a marvelous competition, and I want to extend my congratulations to all the participants, their teachers, their instructors, their attorney assistants and instructors for how well you've done in the competition and for the fact that you made the finals this evening. It's going to be my pleasure and honor to work with all of you this evening. We should all take a deep breath and enjoy ourselves. This is going to all go fine. I am honored to be working with 4 scoring attorneys, all of whom have appeared in my court on numerous occasions, all of whom are outstanding trial attorneys: Pamela Mathieson, Samuel Forbes Roberts, Creighton Mendeville, and Aaron Muhammad. So I thank them for their efforts this evening, and I'll look forward to working with them regarding their involvement as scoring attorneys. At this point, let's move forward with the trial itself. Would our student bailiff please call the court to order?
All rise. Superior Court of the State of California, County of Santa Cruz, Department 831 is now in session. Judge Volkman presiding. Please be seated and come to order. Please turn off all cell phones and refrain from talking.
Thank you very much. I appreciate that. To help myself and the attorney scorers, will the prosecution team please state your names and roles?
Good evening, Your Honor, scoring attorneys. My name is Sierra Fong, spelled F-O-N-G, and tonight I'll be presenting the pretrial motion for the prosecution. May our attorney team please introduce themselves?
Please.
Good afternoon, Your Honor, scoring attorneys. My name is Andres August, spelled A-U-G-U-S-T. Tonight, I'll be presenting the opening statement for the people, as well as the direct examination of Angel Russell and the cross-examination of Danny Emling.
Good evening, Your Honor, scoring attorneys. My name is Madison Alwell, spelled A-H-W-A-L. Tonight, I will be conducting the direct examinations of Terry Edwards and Dr. Charlie Dunn, as well as the cross-examination of Francis Yazzie.
Good evening, Your Honor, scoring attorneys. My name is Gregor MacDonald, spelled M-A-C-D-O-N-A-L-D. Tonight, I will be delivering the direct examination of Deputy Sheriff Tony Garrett, the cross-examinations of Dr. Tyler Clay and the defendant, Jamie Kobe, and the closing arguments for the people. May our witnesses please introduce themselves?
Please.
Good evening, Your Honor, scoring attorneys. My name is Dylan Childs, spelled C-H-I-L-D-S, and tonight I will be Angel Russell.
Good evening, Your Honor, scoring attorneys. My name is Mason Davis, D-A-V-I-S, and tonight I am Terry Edwards.
Good evening, Your Honor, scoring attorneys. My name is Ari McNeil, spelled M-C-N-E-I-L, and tonight I am Deputy Sheriff Tony Garrett.
Good evening, Your Honor, scoring attorneys. My name is Evie McNulty, spelled M-C-N-U-L-T-Y. May our clerk please introduce themselves? Oh, tonight I am Dr. Charlie Dunn.
Thank you.
Good evening, Your Honor, scoring attorneys. My name is Anais Hewitt, spelled H-U-E-T, and I will be the clerk for tonight's trial. I will give visual and verbal time signals of 2 minutes, 1 minute, 30 seconds, and stop. May our attorney coaches and faculty advisor please introduce themselves?
Please.
Good evening, Your Honor, and scoring attorneys. My name is Sarah McCarthy. I am an attorney coach for Team E.
Good evening, Your Honor, scoring attorneys. Diana August, attorney coach for Team E.
And good evening, Your Honor, and scoring attorneys. I'm Devin Lincoln, faculty advisor for Team E.
Thank you very much. It's a pleasure seeing all of you this evening. As for the defense team, would you please state your names and roles at this time?
Good evening, Your Honor. My name is Claire Murray, M-U-R-R-A-Y, pronouns she, her, and I am arguing the pretrial motion for the defense. May my co-counsel please introduce themselves?
Yes.
Good evening, Your Honor. My name is Eleanor Attard, A-T-T-A-R-D, pronouns she, her, counsel for the defendant, Jamie Kobe, in this action. This evening, I'll be conducting the direct examination of Danny Emling and the cross-examination of Dr. Charlie Dunn. I will also be presenting the opening statement.
Good evening, Your Honor. My name is Zoe Wolfson, WOLFSEN, pronoun she, her, counsel for the defendant Jamie Kobe in this action. I will be presenting the direct examinations of Francis Yazzie and Dr. Tyler Clay and the cross-examinations of Angel Russell and Terry Edwards.
Good evening, Your Honor. My name is Lolette Edwards, EDWARDS, pronoun she, her, counsel for the defendant Jamie Kobe in this action. Today, I'll be conducting the direct examination of Jamie Kobe and the cross-examination of Deputy Sheriff Tony Garrett. I will also be presenting the closing argument. May our witnesses please introduce themselves?
Yes, please.
Good evening, Your Honor. My name is Brandon Greenleaf, GREENLEAF, pronouns he, him, and I am Jamie Kobe.
Good evening, Your Honor. My name is Sophie Timichin, TIMUCIN, pronouns she, her, and I am Francis Yazzie.
Good evening, Your Honor. My name is Sonia Ukropina, UKROPINA, pronouns she, her, and I am Danny Emling.
Good evening, Your Honor. My name is Natalie Perry, PERRY, pronouns they, them, and I am Dr. Tyler Clay. May our bailiff please introduce himself?
Please.
Good evening, Your Honor. My name is Flynn Rorty, RORTY, pronouns he, him, and I'll be your bailiff. At this time, I would like to remind the court to turn off all cell phones and to keep video and microphone turned off unless presenting. At this time, their unofficial timekeeper, please introduce themselves.
Good evening, Your Honor. My name is Kitten McClellan, MCLELLAN, pronoun she, her, and I am your unofficial timekeeper. May the attorney coaches and teachers for Team J please introduce themselves?
Yes, please.
Good evening, Your Honor. Mary Fukai, attorney coach.
Good evening. I'm Stacy Newsom Kerr, the teacher coach.
Thank you very much. A couple of instructions I need to complete at this time. You must complete your presentations within the specified time limits. The clerk will signal you as your time for each section of the presentation begins to run out. When your total time for each section runs out, you will be stopped, even if you have not finished. Attorneys must call 4 witnesses within the time limit. This is a bench trial. At the end of the trial, I will render a verdict of guilty or not guilty in relationship to the charge brought. The teams will be rated based on the quality of their presentation, independent of my verdict. Barring unforeseen circumstances, no recesses will be called. If for any reason a recess is necessary, team members should remain in their appropriate places and should have no contact with spectators or coaches. Remember that objections are limited to the California Mock Trial Simplified Rules of Evidence located in case packet. If there are no questions, the pretrial arguments will begin. Both sides will have 4 minutes to present their arguments. The defense will begin. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your argument, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. So is counsel for the defense ready to begin as to the pretrial motion issue?
Yes, Your Honor. May I begin?
At your convenience, please.
Good evening, Your Honor. Today, the defense moves to exclude People's Exhibit A, the snake-feeding tongs, on the grounds that this photograph was obtained through illegal search and seizure on the part of Deputy Sheriff Tony Garrett, and therefore in violation of the defendant's Fourth Amendment rights. Katz v. U.S. institutes a 2-part test to determine Fourth Amendment protection. The first part asks whether a person has exhibited an expectation of privacy, and the second asks whether this expectation would be considered reasonable by society at large. Both of these qualifications were met in Mr. Kobe's situation. His backyard is enclosed by a 6-foot-tall fence, keeping the area out of plain view, and any reasonable person would have an objective expectation of privacy in their own enclosed backyard.
Why shouldn't the court analogize this situation with Ciarollo and consider this viewing as non-obtrusive and occurring in a public airspace?
Well, Your Honor, in Sorolo, the plane is flying over in public airspace, and so it was ruled that any person with an airplane in the space could also see this. However, in this case, first of all, this security camera is on Eric Smith's private property and not seen from public space. And also the placement of the snake tongs and the fact that there is a 6-foot-high fence around the yard means that these snake tongs are not in plain view, and a member of the public would not be able to see the snake tongs from the public land next to the property.
Thank you very much. Please continue.
Because of the factors previously stated, the surveillance of Mr. Kobe's yard did in fact constitute an unreasonable search. US v. Dunn includes its own test pertaining to the Fourth Amendment. However, this one addresses protection offered to curtilage. This test, with 4 parts, examines proximity, enclosure, nature of use, and steps taken to protect an area from view. This is supported by US v. Romero Bustamante, which stated that the search of the defendant's enclosed and connected backyard was unreasonable. Similarly, Mr. Kobe's backyard is directly connected to his home, and as previously stated, it is enclosed by a 6-foot-high fence, exhibiting clear protection from public eye and qualifying the land for Fourth Amendment protection.
Why shouldn't the court, and I'm sorry to interrupt you, but why shouldn't the court follow the opinion in Caro that there was really no meaningful interference in relationship to your client's situation?
Well, Your Honor, US v. Caro was one instance of tracking, whereas this is over the course of 7 months. They're not, these two situations are not the same. And additionally, in Caro, the container that was tracked was brought to the defendant, not placed directly in the defendant's property in that situation. Whereas here, this camera is surveilling Mr. Kobe's property from the very start.
Thank you very much. Please continue.
The protection offered through US v. Dunn to the curtilage was violated when Deputy Sheriff Garrett provided Smith with the high-quality security camera and instructed him on both where to place it and how to share 24/7 surveillance directly with the police department. The security camera was given to Smith by the police department, who then proceeded to tell him precisely where to place it and how to upload the footage so that the police would have constant and permanent access to Mr. Kobe's yard. The round-the-clock surveillance continued from October to April, 7 months of invasive and warrantless surveillance. US v. Jones warns us of the dangers of living in an era where surveillance can be carried out without physical intrusion, stating that a search occurs whenever the government violates a reasonable expectation of privacy, not only physically, but with technology as well. And Schaefer v. City of Boulder tells us that duration and intensity of surveillance must also be taken into account. The camera used was state-of-the-art, detecting motion from 125 feet and resulting in intense surveillance of Mr. Kobe's yard. The camera is running constantly for over half a year. People v. Weaver supports those previous two holdings by ruling that police had far more access using technology than they otherwise would have, allowing them to track a vehicle for 65 days. It distinguishes itself from US v. Knotts in that Knotts is one instance of tracking, whereas People v. Weaver occurred over the course of approximately 2 months. Weaver also
significance, and I'm sorry to interrupt you again, thank you. What significance, if any, is the presence of a chain link fence regarding a portion of the enclosure surrounding your client's property?
Well, Your Honor, this chain link fence is only 3 feet wide, and so it does not give a clear view of the entire backyard. And additionally, in US v. Romero Bustamante, the fence surrounding the backyard was partially brick and partially chain link, and it was still ruled that this enclosure was enough to constitute protection from public view and protect this land as curtilage.
Thank you very much. Please continue.
People v. Weaver states that in this day and age, with the level of technology available, there's a high risk of police overstepping authority. An overstep that most certainly occurred in this situation when Deputy Sheriff Garrett provided Smith with the high-quality security camera and performed the 7-month-long constant surveillance of Mr. Kobe's home. The actions of Deputy Garrett over the course of these 7 months were invasive and unreasonable. Deputy Sheriff Garrett violated the defendant's Fourth Amendment rights, and therefore the evidence obtained in the search, the photograph of the snake tongs, must not be admissible in today's trial. Thank you.
Thank you very much. Is counsel for the prosecution ready to begin?
Yes, Your Honor.
At your convenience, please.
Thank you. For the convenience of the court, my name is Sierra Fong. Your Honor, and may it please the court. Last October, Eric Smith positioned a 24-hour video surveillance camera on his own property to protect it from theft, vandalism, and potential bodily harm. Defendant Kobe received notice of the surveillance and was aware of its functionality to protect Smith's property. The image obtained from the camera is admissible for 3 reasons. First, Kobe's backyard does not constitute as curtilage of their residence. Second, because it is in plain view and adjacent to a public state park, Kobe's property has no societally reasonable expectation of privacy. Finally, the defendant received notice of the surveillance that was not of his home, but of Smith's property, therefore failing to establish an expectation of privacy. There is no reasonable expectation of privacy because the observations were made in a public space and on Smith's property. In California,
and I'm sorry to interrupt you, but let's talk about curtilage for a moment. Why isn't this situation similar to Dunn, at least in relationship to the curtilage factors, proximity to the home, enclosed area, nature and use of the area? Why shouldn't the court focus on those factors?
Yes, Your Honor, good question. One of the main distinguishing factors from U.S. versus Dunn is that Kobe's property is directly adjacent to a public state park. And so, and the chain link fence causes the entirety of the yard to be visible to the public. And so by eye, a member of the public would be unable to discern where the state park ended and Kobe's park began, or in Kobe's property began.
Thank you very much. Please continue.
Thank you. In California versus Cirillo, the court established that non-intrusive observations, which take place either from somewhere where one is allowed to observe or in a public space, are consistent with the Fourth Amendment, to reiterate. The victim placed a non-intrusive camera in their own backyard, which was not installed with the intention of monitoring the defendant's private life, but rather to protect Smith's property from theft and vandalism. Additionally, Kobe's backyard does not constitute as curtilage of their residence under the 4-pronged test established in U.S. versus Dunn, which looked at the proximity to the area of the residence, the presence of an enclosure surrounding the home, steps taken by residents to protect the area from observation, and the nature of uses of the area. In our case, Kobe's backyard is directly adjacent to a public state park and is adjacent to Smith's own property. Moreover, the 4-foot-tall chain link fence causes the entirety of the yard to be visible to the public without one ever having to take a single step onto the property.
Why shouldn't this court focus on the case that was outlined by opposing counsel, and that's Romero Bustamante, that we're talking about a relatively small space, an enclosed space, it's near the defendant's home, and find that a warrant should have been obtained?
Yes, Your Honor. Even though chain link was considered curtilage in Romero Bustamante, the main distinction in our case is that Kobe's backyard is directly adjacent to a public state park.
Thank you very much. Please continue.
The camera also does not serve any purpose that could not have been performed manually. In United States versus Knotts, law enforcement officers used a radio transmitter to track illicit chemicals into a lab. The court ruled that the actions of law enforcement officers were not in violation with the Fourth Amendment, as the technology did not serve any function that the police could not have performed visually. It only made the process easier. Sheriff Garrett would have come several more times, but instead, due to the nature of the calls, it seemed feasible to place a camera and have it serve in the same capacity.
From your perspective, is there no significance to the fact that in Knotts there was consent from the employer regarding this issue?
Kobe was well aware of the camera's presence, and yet he never established an expectation of privacy. And other cases outline that there are very distinctive ways in which an individual can outline their expectation of privacy, such as established in Schaefer. which I will address in a second.
Do you draw a line of demarcation between, for example, a radio transmitter in a container versus the privacy of one's own home or backyard?
This camera was publicly available and is not superior technology, unlike the radio transmitter, which only the police would have had access to. And
my question might have been poor. I'm talking about container versus the privacy of someone's home or backyard. Do you see any line of demarcation in that regard that the court should take into account?
Apologies. I do not see any line of demarcation, as Kobe never established an expectation of privacy in his home.
Thank you very much. Please continue.
Similar to this case, in Schaefer versus City of Boulder, the neighbor of the defendant was provided surveillance cameras by police to monitor the defendant's backyard. However, unlike in Schaefer, Kobe never establishes his expectation of privacy. For 201 days, Kobe was well aware of the camera's presence, yet only notified Smith once. Despite the sign attached to the camera, Kobe either forgot about it or was unconcerned about its presence. In Schaefer versus City of Boulder, the defendant clearly established an expectation of privacy by asking both the police and his neighbors multiple times to take the cameras down, and even added additional feet of wood to his backyard fence.
30 seconds.
There is no Fourth Amendment violation of the defendant because the defendant did not establish a reasonable expectation of privacy by any means, verbal, physical, or societal. Furthermore, the surveillance was that of Smith's own property that is subject to plain view and that is not enclosed in any curtilage. For these reasons, the people request the court to deny the motion and admit the image into evidence. Thank you, Your Honor.
Thank you very much. Does the defense have a rebuttal?
Yes, Your Honor. May I begin?
At your convenience. Thank you, counsel.
Your Honor, the prosecution argues that the purpose of the camera was not to monitor the defendant. However, we know this to be, in fact, the opposite. It is explicitly stated that the purpose of the security camera was to, quote, gather evidence against Kobe. This is most certainly monitoring the defendant's private life. Additionally, the prosecution has argued that the presence of the gate means that the entire yard is in plain view. We also know this to be untrue. This gate is only 3 feet wide. It most certainly does not give a view of the entire property. And additionally, going back to US v. Romero Bustamante, that backyard was enclosed partially by brick fence and partially by chain link fence, not only a gate, but a fence as well. And that backyard was constituted as curtilage similar to US v. under the qualifications set by US v. Dunn. Additionally,
1 minute.
The prosecution has argued that Jamie Kobe never established an expectation of privacy verbally, physically, or societally, and that is not true. Verbally, Jamie Kobe asked for the security camera to be taken down. Physically, the presence of a 6-foot-high fence surrounding the yard protects the area from plain view, both from Eric's yard and from the public land. And societally, any person would have an objective expectation of privacy in their own
30 seconds.
backyard.
What's your position regarding your worthy opponent as to the efforts in Schaefer by the individual? And I believe that your opponent is taking the position that there weren't such steps in this case, and that in Schaefer there were steps taken to make the area more private and less visible. What's your view in that regard, please?
Well, Your Honor, it is true that Jamie Kobe did not build up additional fencing, but Your Honor, a person should not need to build up additional fencing just to have privacy in their own backyard. The fact that Jamie Kobe asked for the security camera to be taken down does display a subjective expectation of privacy and does display him taking steps to protect the area from view.
Thank you very much. Why isn't this matter like the Dunn case, where it's similar to peering into the open end of a barn, peering into the open end of a backyard?
Well, Your Honor, in this case, because of the placement of the snake tongs, it would be impossible to see them from the public land unless a person not only leaned peered through the chain link gate, but leaned over it into the yard. And that would be crossing the line from the public space into Jamie Kobe's private property. And so it's not the same thing as looking through the gate or looking through the fence. Additionally, Your Honor, the prosecution has argued that the snake tongs could be seen from the public land. However, it's important to distinguish the fact that the security camera was not on the public land. It was in Eric Smith's private property. And so the footage obtained in this search could not have been performed visually because it is not the same location of surveillance.
Thank you very much. Please continue.
Your Honor, because of the factors previously mentioned, the photograph of the snake tongs was obtained in violation of the defendant's Fourth Amendment rights, and therefore it must not be admissible in today's trial. And I ask that you grant this motion. Thank you.
Thank you very much. Prosecution have a rebuttal?
Yes, Your Honor. May I proceed?
Please proceed. Thank you.
I would like to begin by challenging the defense's presentation of the facts. The defense maintains that the way in which this image was obtained violated the defendant's Fourth Amendment right to a reasonable expectation of privacy. However, contrary to what the defense asserted, our situation fails to meet the requirements of the test established in Katz, which hinges on whether or not an individual exhibits an expectation of privacy. I would again like to reiterate that Kobe never took any actions to protect his property from observation.
Well, let me follow up on Katz. Isn't there a reasonable expectation of privacy when we're dealing with someone's backyard?
Katz makes it a requirement that an individual must establish this expectation of privacy, and Kobe never did.
All right, thank you. Please continue.
Other cases have established that there are, in fact, distinctive ways in which an individual can establish an expectation of privacy. Such is demonstrated in Schaefer, where the defendant alerted the police and his neighbors several times about his concerns and actively attempted to obstruct the camera's view. In response to past disagreements between Kobe and Smith, Kobe clearly showed no hesitation in regards to expressing his discontent with Smith's actions. Therefore,
you would agree, I'm sorry to interrupt you, you would agree pursuant to Schaefer that this gentleman's backyard is indeed curtilage, correct?
Yes, I agree.
All right. And your line of demarcation between Schaefer in this case is that there were not more active steps taken by the target of this surveillance in ensuring that his backyard would be private?
Yes, Your Honor, there were no active steps taken by the defendant. There was a single mention of the camera over the course of 201 days.
Well, let's follow up on the 201 days. Counsel has cited Weaver. Shouldn't the court get involved and provide required oversight as they described in Weaver when we're talking about surveillance that is so extensive?
Your Honor, the individuals in this case had a history of petty altercations, and Kobe was well aware of the camera's presence. There was a sign attached to the camera that said, "Smile, you're on camera." Kobe must have either not cared about the camera's presence or completely forgotten about it.
Thank you very much. Please continue.
Because Kobe failed to establish a comparable expectation of privacy, Schaefer's test does not even begin to apply. The defense also maintains that the camera did a task that could not have been performed visually. Yet, previous to the installation of the camera, the sheriff's actions served the exact same purpose. Previously, the sheriff responded to over a dozen calls due to Kobe and Smith's frequent altercations. Smith could not constantly monitor his yard, nor could he further require the sheriff's presence every time he feared Mr. Kobe's intrusion. Thus, the most feasible way for Smith to protect his property was to place a 24/7-hour video surveillance camera that would upload footage of anyone crossing over to his property. Thank you, Your Honor.
Thank you very much. I appreciate the arguments of both attorneys. Before I rule on this motion, the students may confer with their attorney or teacher coaches regarding any pretrial motion irregularities. If you'll please do that now.
No irregularities, Your Honor.
Thank you. Any any pretrial motion irregularities noted by the other side,
None from the
please?
defense, Your Honor.
Nothing? All right. Thank you very much. I appreciate the arguments of both sides, outstanding efforts by both sides. I want to respectfully deny this motion. At this stage, we'll proceed with the balance of the trial in relationship to evidence. Attorneys may present physical evidence for inspection. From the prosecution's perspective, do you have any physical evidence you'd like to present for inspection, please?
Your Honor, at this time, we would like to mark all exhibits for identification, for the convenience of both teams, A through E.
Any objection from the defense perspective, please?
No objection, Your Honor.
Thank you. And from the defense perspective, anything further you'd like to add regarding the issue of physical evidence you'd like to present for inspection?
No, Your Honor, I believe those are all exhibits. Thank you.
Thank you very much. And at this point, we'll proceed to describe the charges directed against the defendant. The prosecution charges Jamie Kobe with first-degree murder, which is an asserted violation of California Penal Code Section 187. It's the unlawful killing with malice aforethought, express or implied, premeditated first degree, or with voluntary manslaughter, which is an asserted violation of California Penal Code Section 192A, the unlawful killing of a human being without malice during a sudden quarrel in the heat of passion. So again, the people of the state of California are charging the defendant, Jamie Kobe, with first-degree murder or voluntary manslaughter of Eric Smith. At this point, we'll proceed with opening statements. Is the prosecution ready to proceed with their opening statement?
Yes, Your Honor, the prosecution is ready.
At your convenience, please.
Thank you. Jamie wanted him dead. Jamie had the weapon. Jamie killed Eric Smith. Motive, means, and opportunity. The defendant had endured months of harassment, humiliation, and bullying from Eric Smith. The defendant was Eric Smith's tenant, and you will hear evidence that Eric Smith cut the power to the defendant's home. This upset them. You will hear evidence that some people did not like Eric Smith as a landlord, but those opinions do not justify his murder. The defendant's feelings about Eric Smith cutting off power and their opinion that their mother was killed because the power was cut off is the most damning evidence of motive in this case. You will hear from Terry Edwards, who overheard the defendant say, "That was it. I am going to kill him." And Jamie was finally going to do it. You will hear evidence of the defendant's means and opportunity when Angel Russell saw them standing in front of the victim's mailbox with a snake cage in hand. The defendant put that snake in the mailbox with the intent to kill the victim, with the intent for the victim to open the mailbox and be attacked by the weaponized snake. How are we to be assured that it was Jamie who did this? You will hear from Deputy Sheriff Tony Garrett that the defendant's house was full of evidence to show that they had a special knowledge of venomous snakes. And after Eric Smith was murdered, the defendant got rid of all such evidence. Dr. Charlie Dunn will testify that Eric Smith died from the snake regardless of any pre-existing health conditions. Don't be distracted. Listen to the facts. The defense will try to argue that Eric Smith was responsible for his own death. Do not be fooled. Jamie Kobe was perhaps more venomous than that snake. Jamie Kobe wanted Eric Smith dead, and they weaponized the snake to do it. At the end of this trial, after you have heard all the evidence, we will ask you to find Jamie Kobe guilty of first-degree murder. Thank you.
Thank you very much. Would the defense like to proceed with an opening statement at this time?
Yes, Your Honor.
At your convenience, please.
Thank you, Your Honor. For the convenience of the court, my name is Eleanor Attard. Your Honor, the threshold question in this case is whether there has, in fact, been a crime at all. Or was Eric Smith's death an accident, a tragic accident, but an accident nonetheless? What will the facts show? The fact is that Eric Smith died within hours after being bitten by a Mojave rattlesnake, a snake that was hiding in his mailbox. We will present the testimony of Dr. Tyler Clay, a court-qualified expert specializing in herpetology, the scientific study of the biology, ecology, and ethology, or behavior of snakes. Dr. Clay will explain that snakes can and do crawl into mailboxes, and that snake that bit Eric was more than capable of doing so. Dr. Clay will explain that snakes commonly hide out in small, dark places during the day to avoid the sun. Dr. Clay will explain that the skin of snakes expands and contracts, allowing them to squeeze into hiding places. Dr. Clay will testify that the Mojave rattlesnake is most active between April and November in California, and that adult snakes shed their skin twice yearly. And in scraping this skin off, they can inadvertently pull their rattles off. The missing rattle is a natural occurrence common to all species of rattlesnake. Dr. Clay will also testify that the capturing and releasing of any venomous snake into something like a mailbox would be extremely risky, regardless of if someone had the proper equipment. The prosecution would like to paint a perfect picture of revenge. Jamie must have put the snake inside the mailbox because he held Eric Smith responsible for his mother's death. Your Honor, while the evidence will demonstrate that the two definitely didn't get along, there was never any violence. The two would frequently call the sheriff's office to make petty and childish complaints about one another, but there was never violence. The evidence will show that Eric Smith was not a very well-liked person in Burnsley. He was a bully who couldn't seem to get along with anyone. He was unreasonable, rude, and rumored to be dealing drugs to minors. Jamie Kobe was not the only person who had problems with him. And Jamie Kobe was not the only person with access to that mailbox. The evidence will show that all of his tenants and anyone else that knew where he lived had access to that mailbox. We don't dispute that Jamie Kobe went to the mailbox. He was dropping off his rent. He had gathered up the cage and other items to sell to help pay for his mother's funeral. Andrew Russell will admit that they did not see anything inside of the cage. They did not see Jamie open the cage or the mailbox. Yes, Jamie did blame Eric Smith for his mother's death, as anyone would, but he knew that she was dying. She didn't have much time left. Anger and grief do not make a murderer. Your Honor, the bottom line is that the prosecution cannot prove beyond a reasonable doubt that a crime has even been committed. By the end of this trial, once you've heard all the evidence, there will only be one just verdict, not guilty. Thank you.
Thank you very much. Appreciate the opening statements of both counsel. Is the prosecution ready to call its first witness?
Yes, Your Honor. Before the prosecution calls their first witness, we would like to request a time check on statements.
That's fine.
Prosecution has 6 minutes and 40 seconds left for closing arguments, and defense has 5 minutes and 38 seconds for closing arguments.
The prosecution calls Angel Russell.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
Please state your name and occupation for the court.
My name is Angel Russell, and I have been a line worker in Burnsley County for 15 years.
What were you doing on April 29th and 30th?
On April 29th and 30th, I was working on a power pole on Raptor Road.
Could you describe your location on that day?
I was approximately 100 feet away from Smith's home.
I'd like to direct your attention to what has been pre-marked as Exhibit C for identification. Do you recognize this?
Yes, I do.
What do you recognize it as?
It's an aerial map of Raptor Road.
Is this a faithful and accurate representation?
Yes, it is.
Your Honor, may Exhibit C be moved into evidence?
Any objection?
None, Your Honor. Thank you.
All right, C will be in evidence. Thank you. Please continue.
What happened on the morning of April 29th?
Well, I was working on the power line on the power pole when I saw a figure exit 46603. They were dressed with a long sleeve t-shirt and jeans.
And who was the person you noticed?
The person I noticed was the defendant, Jamie Kobe.
What was Jamie doing?
They were walking towards the mailbox.
Did the defendant have anything with them?
Yes, they had a bulky bag with some items in it that I could not identify and what looked to be a medium-sized cage.
I'd like to direct your attention to what has been pre-marked as Exhibit E for identification. Do you recognize this?
Yes, I do.
What do you recognize it as?
It is the cage that Kobe was carrying.
Is this a faithful and accurate representation of the cage?
Yes, it is.
Your Honor, may Exhibit E be moved into evidence?
Any objection?
None, Your Honor. Thank you.
Thank you. E will be in evidence. Please continue.
How is the defendant acting with this cage?
They kept looking down at it.
And later, while you were working on Raptor Road, did you see Eric Smith?
Yes, I did. I saw him exit his house and I gave him a little wave and then turned back to my work.
And what happened after that?
Well, I turned around and saw him reach into the mailbox where he was bitten by the snake. I jumped off the pole and ran to go help him. I called out for help and tried to suck the venom out of his wound. I don't know if it did much.
And how did Eric react to this?
He stumbled backwards. He stood up and screamed, "Jamie." Then he tried to stumble back towards his house, but I told him he should sit down.
And the next day, did anything happen?
Yes, I came to work early in the morning and I saw Eric Smith dead on his lawn.
And what did you do when you saw Eric Smith?
Well, I called 911.
How long did you work across from the victim's mailbox on April 29th?
I worked from morning to evening.
And during those hours, did you see anybody other than the defendant near the victim's mailbox?
The only person that I saw approach Mr. Smith's mailbox was Jamie Kobe.
Thank you, Your Honor. No further questions.
Thank you very much. Any cross-examination?
Yes, Your Honor. And for the convenience of the court, my name is Zoe Wolfson. On April 29, 2021, you were working on a power line 100 feet away from Smith's home, correct?
Yes, I was.
And just after 8:30 that morning, you saw someone walking towards the mailboxes in front of the buildings, right?
Yes.
You said that person was carrying a cage and a bag?
Yes.
But you didn't see them take anything out of the cage or the bag that they were carrying, right?
No, I was focused on my work.
To be clear, you did not see a snake in the cage?
I do not remember if I saw anything in that cage.
You did not see the person open the mailbox, did you?
No, because I was focused on my work.
Right. You didn't see the person put anything in the mailbox.
No, I did not.
In fact, the next time you noticed any activity at the mailbox that day was when Mr. Smith opened it, correct?
Yes.
Thank you. No further questions.
Thank you. Any redirect at this time?
No, Your Honor. May the witness be excused?
Yes, he may. Thank you very much for your testimony. Next witness, please.
And at this time, the prosecution requests a time check on direct examinations.
Prosecution has 10 minutes and 59 seconds left for direct and redirect examination, and defense has 9 minutes and 6 seconds left for cross-examination.
Your Honor, the prosecution calls Terry Edwards to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
For the convenience of the court, my name is Madison Alwal.
For the convenience of the court, my name is Mason Davis.
Good evening, Mr. Edwards. Would you please introduce yourself for the court?
My name is Terry Edwards, and I'm a retired lawyer.
Are you familiar with Eric Smith?
Yes, Mr. Smith and I have been friends for a long time.
And do you know the defendant?
Yes, Mr. Smith, Mr. Kobe, and I have all lived on Raptor Road for a long time.
Can you please tell me about Eric and Mr. Kobe's relationship?
It was a stressful relationship between a tenant and landlord. I know they got into several fights. One time, Mr. Kobe threw animal feces onto Mr. Smith's porch, which was unacceptable. Mr. Smith was mostly angry with Mr. Kobe for not paying rent.
And what was your relationship with the defendant like?
It was a friendly relationship that had its edges.
What do you mean by that?
Mr. Kobe did some work for me a while back, but did not finish it up to my satisfaction and requested more money to finish the job. But past aside, he invited me to his funeral.
And where were you on? And where were you on April 28th?
I was attending Jamie's mother's funeral.
And did you see the defendant there?
Mr. Kobe was there.
And how did the defendant seem?
Mr. Kobe looked angry. Mr. Kobe made several remarks like this was it, and they were finally going to do it. I overheard those, of course. Whenever I inquired on what those remarks were about, Mr. Kobe told me to go away and he would not want to talk to me.
And did you see Eric Smith at the funeral?
Mr. Smith was there.
Did Jamie and Mr. Smith interact at all?
I saw Mr. Smith and Mr. Kobe go outside, and I followed to prevent any physical conflict.
And what happened after that?
Mr. Smith said something that provoked Jamie, and Jamie responded with that Jamie did not want Mr. Smith at the funeral and blamed Mr. Smith for Jamie's mother's death.
And how did this argument end?
I suggested that they separate and discuss this at another time, but Mr. Kobe said never and hurried off to their car. Eric said then he would go home also.
What did you do after the funeral?
Few hours after the funeral, to check up on Mr. Kobe, I drove to their residence and I found them in their garden.
And what was the defendant doing?
Mr. Kobe looked emotionally drained in their garden. I rolled down the window to talk to them, and I heard the words, "I'm going to kill him," screamed by Mr. Kobe. I suggested that they they soon go to rest, and Mr. Kobe said they would after they finish something important.
Thank you. No further questions, Your Honor.
Thank you. Cross-examination, please.
Excuse me, Your Honor, before we continue, one of our attorneys lost internet and is trying to get back in and is not being allowed access. And I have no idea who to call.
Okay, let me give you a number in that regard.
Judge, this is Martine Watkins here.
Great.
I have been keeping an eye out for that, but I'm wondering if maybe I wasn't made co-host in order to be able to monitor individuals who may have gotten kicked out. So I will go ahead and also problem solve on that too.
Okay. Her name is
now. I'm
name
now
is Lola
co-host.
Edwards.
Okay, let me let them in. And there's another individual also joining. Okay, I have two individuals that joined that I was able to let in.
Great, thank you.
Thank you very much. All right. Cross-examination at counsel's convenience, please.
Yes, Your Honor, thank you. For the convenience of the court, my name is Zoe Wolfson. You were friends with Eric Smith, correct?
Correct.
But you didn't like Jamie Kobe, did you?
He was a tough person to get along with.
And when you hired Jamie to do work for you, you wanted Jamie to complete work that you had not yet paid him for, correct?
Well, I paid a large amount of money the first go around, and Jamie requested more money to finish the job.
Is that a yes or a no?
I paid a large amount of money the first go around, but then Jamie requested more money to finish the job.
At the funeral, when you tried to talk to Jamie, he told you to go away, correct?
Objection, Your Honor. This question calls for hearsay.
Response, please.
Yes, Your Honor. There is no truth in the statement of go away. It's not being used to prove the truth of anything, and it can't be false. Go away is like asking a question. It can't be true or false.
So you do not want me to accept this statement for the truth of the matter asserted. Is that correct?
Correct.
All right. Response, please, from the objecting party.
No response, Your Honor.
Thank you. I'll respectfully overrule. Please re-ask the question. Let's see if we can get a response.
Yes, Your Honor. Thank you. At the funeral, when you tried to talk to Jamie, he told you to go away, correct?
Correct.
Outside the funeral venue, after Jamie said, "This is it, I'm going to do it," you heard Jamie tell Eric Smith that he was not invited and to leave, right?
Correct.
And Mr. Smith asked Jamie when he was going to move out, correct?
That is what I thought I heard.
Right. It was at that point that Jamie yelled, "You killed my mother," right?
Yes.
Mr. Smith then pointed his finger at Jamie and yelled, "It's your fault your mom died. You should have taken better care of her." Correct?
Objection, Your Honor. This question calls for hearsay.
Response, please, as to hearsay.
Yes, Your Honor. This is not going for the truth of the matter. It's going to show the state of mind.
State of mind of whom?
It's going to show the state of mind of Jamie Colby.
Response, please, in light of the limited offering of that evidence to show the state of mind of Jamie Colby, please.
Yes, Your Honor. This statement was made by Eric Smith, if I recall. I'm not sure how that statement by the victim would contribute to the state of mind of Jamie Colby.
I'll overrule the objection, allow the question to stand. Please ask it again and see if the witness can respond.
Yes, Your Honor. Thank you. Mr. Smith then pointed his finger at Jamie and yelled, "It's your fault your mom died. You should have taken better care of her," right?
Correct.
At that point, Mr. Smith laughed, turned away, and threw up his hands, correct?
Correct.
And after Jamie said, "This is going to," after Jamie said, "This is it, I'm going to do it," he confronted Eric Smith and told him he didn't want him there and told him to leave, right?
That is what I believe.
Jamie didn't go after Mr. Smith, did he?
Jamie clenched his fist, but did not pursue that any longer.
So Jamie didn't take a swing at him, correct?
No, because I stepped in to make sure that wouldn't happen.
At dusk, you went over to Jamie's house and saw Jamie working in his garden when you arrived, right?
I saw Jamie in their garden.
Yes. You testified that as you rolled down the window, you heard Jamie say, "I'm going to kill him," correct?
Correct.
You didn't ask what he was talking about, though, right?
Correct.
In fact, your only response was to tell him to go get some rest, correct?
It was an emotional day, so yes.
Right. You didn't take that statement seriously, did you?
No.
Thank you. No further questions.
Any redirect of this witness, please?
No redirect, Your Honor. May the witness be excused.
Yes, thank you very much. Next witness, please.
Your Honor, at this time, the prosecution would like to request a time check for direct examination.
And the defense would like to request a time check for cross-examination.
Prosecution has 8 minutes and 2 seconds left for direct and redirect examination, and defense has 6 minutes and 26 seconds left for cross-examination.
At this time, the prosecution calls Deputy Sheriff Tony Garrett to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
Your Honor, may I proceed?
Yes, thank you.
Good evening, Deputy Garrett. Could you please introduce yourself to the court?
Good evening. My name is Tony Garrett, and I've been a deputy sheriff in Burnsley County for about 20 years.
And in that time, have you encountered a man named Eric Smith?
Yes, I have. Smith has lived in Burnsley County for the entire time I've worked here.
Are you aware of what Mr. Smith does for a living?
As far as I'm aware, he worked as a contractor before starting to rent out properties about 15 years ago.
Have you ever met any of his tenants?
Yes, notably the defendant, who was his neighbor.
How is their relationship as neighbors?
I'd say they had a very stressed relationship.
Objection, Your Honor. Lack of foundation as to how this witness would know what their relationship is like.
Response, please, regarding the foundation objection.
Your Honor, this witness has stated that they are aware of and have encounters with Eric Smith as well as Jamie Kobe, and therefore they would have a reasonable foundation to talk about their relationship, as they have stated they have encountered both of them.
Anything further regarding your objection, please?
None, Your Honor. Submitted. Thank you.
I'm going to sustain the objection. Please lay further foundation before asking any further regarding those issues.
Have you ever responded to calls from Eric Smith?
Yes, I have. Over half a dozen times for everything from parking complaints to noise complaints.
Did you ever do anything to perhaps curtail future calls from Eric?
Yes, at one point I gave Eric a security camera after he accused the defendant of breaking into his property.
Objection, Your Honor. Relevance? This testimony is not relevant.
Relevance from your perspective, counsel?
Your Honor, this testimony lays foundation as to how the camera was placed and how Exhibit A was observed and captured.
Anything further regarding your relevance objection, please?
Yes, Your Honor. What is the, may I ask what the relevance of the break-in is?
I'll tell you what, I'm going to respectfully overrule the objection. Please ask the question again.
Thank you.
And we'll see if we can get a response. Thank you.
Did you ever do anything to curtail future calls?
Yes, I did. At one point, I gave Eric a security camera after he accused the defendant of breaking into his property.
Do you know what Mr. Smith did with that security camera?
Well, I showed him how to set it up, including how to share the footage with the police department if he so chose, but I'm not sure what he did with this.
I'd like to move on to April 30th, 2021. What were you doing that morning?
I was on patrol that morning when a call came around 9 a.m. to 46601 Raptor Road due to an old man's body being found. I recognized the address as Eric Smith's and responded.
What did you find at Eric's address?
I found Eric laying face down in front of his house. I checked his pulse and I unfortunately found none, so I began to inspect his body.
Was there anything significant on the body?
Yes, there are puncture marks on his left wrist that I believe to be those consistent of a snake bite.
Knowing that he was bitten by a snake, how did you proceed?
I talked to Angel Russell, who was the one to find the body. They directed me to the body of a dead snake. I believe it to be a rattlesnake based on its markings and fangs, but it did not have a rattle.
Objection, Your Honor. This is an improper lay witness opinion.
As to the type of snake?
Yes, Your Honor.
All right, response regarding that aspect of the testimony?
Your Honor, this witness is a lay witness, and they have experience in the desert, including over 20 years working there. They can opine on what type of snake this is. It is a lay opinion, but they can state their opinion.
Anything further regarding your objection, please?
None, Your Honor.
Thank you. I'm going to overrule the objection. Goes to the weight of the evidence, and it's subject to cross-examination. So please proceed, counsel.
Did you get a chance to answer that question?
Yes, I did. Could you ask the next question, please?
How did you proceed after you found the snake?
Well, Angel Russell told me that the snake had bitten Eric Smith from the mailbox, so I checked out the mailbox.
I'd like to direct your attention to Exhibit B. Could you describe this image to me?
Yes. This is the picture of Smith's mailbox they took at the time. I'd say it sits a couple of feet off the ground on some wood.
Is this a faithful and accurate representation of that image?
Yes.
Your Honor, at this time, I ask that Exhibit B be moved into evidence.
Any objection to B being in evidence?
No objection, Your Honor.
Thank you. B will be in evidence. Please continue.
Could you describe how you found the mailbox that morning?
I found an open with a slant on the top measuring 1 3/4 inches across. I checked for visible fingerprints and I found none, so I dusted for latent ones.
Did you find any?
Yes. Later on in the investigation, they were found to belong to Danny Enlings, Eric Smith, and the defendant. All of them, except for the defendant, could be ruled out of Eric Smith's murder.
Objection, Your Honor. There's a lack of foundation.
Response as to lack of foundation, please.
Your Honor, there is no response. I will lay the foundation now.
So I'm going to sustain the objection and I'm going to strike the last sentence at this point. Please continue with your examination.
Excuse me. Did you ever search the victim's home that day?
I did. I found rent checks containing rent from Eric's tenants in his home, but I could not find the defendants.
All right. Did you ever talk to the defendant that day?
Yes, they told me they hadn't heard anything that morning and intended to drop off rent to Mr. Smith's mailbox the morning before. So I decided to return to the station with the evidence I had collected.
Did you return to the scene at a later date?
Yes, I did. On May 1st, intending to interview Terry Edwards and Francis Yazzie, who are both Eric's neighbors.
What did you learn from them?
Well, Terry informed me of an argument at the defendant's mother's funeral, and Yazzie was able to corroborate.
Objection, Your Honor. This testimony contains hearsay.
Response, please.
Your Honor, this is being offered for the limited purpose of demonstrating why the officer proceeded as they did and how it affected their investigation.
Anything further regarding your objection, please?
None, Your Honor.
In light of the representation of counsel, I'll respectfully overrule the objection, but accept the testimony for the limited purpose outlined by counsel. Please continue.
How did this affect your investigation?
I remember the camera, and I retrieved an image from the morning of Smith's death, which showed a picture of the defendant's back garden.
Could you just, excuse me, I'd like to direct your attention to Exhibit A. Could you describe this image to me?
This image contains a pair of snake tongs, which are useful in handling any potentially dangerous snakes, and a small object. I'm not sure, but could have been a rattlesnake's rattle.
Objection, Your Honor. This is an improper lay witness opinion.
Response regarding improper opinion, please.
Your Honor, this witness is allowed to opine on common experience. Again, they have operated and lived in the desert for around 20 years, and they are simply stating their opinion and how it affected their investigation.
Anything further regarding your objection, please?
Yes, Your Honor. This witness is not an expert in snake behavior or in snake anatomy, and therefore is not qualified to offer testimony about either.
I'll sustain the objection from a speculation perspective. The verb used was may. I think it's speculative, and from that perspective, not relevant, will not assist the trier of fact. So I'll strike that sentence. And next question, please.
Is this the image you described coming from the back of the defendant's garden?
Yes.
And is this a faithful and accurate representation of that image?
Yes.
Your Honor, at this time, I ask that Exhibit A be moved into evidence.
Any objection to A?
No objection, Your Honor.
A will be in evidence. Thank you.
How did this image affect your investigation?
With what I learned from Edwards and Yazzie, I decided to talk to the defendant the next day.
What did you learn when you talked to the defendant?
Well, they allowed me to search their property on May 2nd.
Was there anything significant inside their property?
Yes, I saw a few books on venomous animals, a tub with around 5 rattlesnake rattles, and some snake-proof boots in the garage.
With all the evidence you collected and what you saw on the defendant's property, how did you conclude your investigation into Eric Smith's death?
Well, knowing the history between the defendant and Smith, as well as the evidence I had collected, I concluded that the defendant likely murdered Eric Smith and arrested them on June 3rd, 2021.
Thank you. No further questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. For the convenience of the court, my name is Lawlette Edwards. May I begin?
Yes, thank you.
You interviewed Angel Russell, Terry Edwards, Francis Yazzie, Danny Emling, and Jamie Kobe in this investigation, and no one else, correct?
Yes.
And in your statement, you said that the mail slot on the top of the mailbox was about 6 inches long and 1 3/4 inches wide?
Yes.
So you did not actually measure this mail slot?
No, but it was a visual inspection, so I would just say about.
Thank you. Jamie gave you permission to search his home and property, correct?
Yes.
He told you that he had a wire trap he had sold a few days earlier?
He did.
During your investigation, you found 3 envelopes on the victim's kitchen counter containing rent checks, not cash, correct?
Yes.
And you never specifically searched for cash?
No.
You concluded that Emling had an alibi and was not a suspect later in your investigation. Is that correct?
I did.
But you did find Emling's fingerprints on the mailbox?
He told me that he had jumped off rent the day before and had not.
Objection, Your Honor. This witness is being non-responsive.
I'll sustain. Please ask the question again. If the witness can offer a response, I would appreciate it. Go ahead.
Thank you. Emling admitted, but you found Emling's fingerprints on the mailbox. Is that correct?
I did.
And Emling admitted that she had put a rent check in the mailbox after the funeral on the 28th? Pardon
Sorry,
me,
I
did you
thought-
hear?
I'm
Excuse
sorry.
me.
I thought someone
The
objected.
witness may not have heard the question. If you could do me a favor and please repeat it, I would appreciate it.
Your Honor, I'm making an objection to the question as it asks for hearsay.
All right, I'm going to have to hear the question again because I couldn't quite hear the question in light of the objection. Go ahead and ask the question one more time, please.
Emling admitted that she had put a rent check in the mailbox after the funeral on May 28th.
All right, and there's an objection as to hearsay.
Yes, Your Honor.
What's your response as to the hearsay objection?
Thank you. This is not offered for the truth of the matter. It is not offered to show that Emling did, in fact, put a rent check in the mailbox, but to show that the officer did not conduct a thorough investigation.
Response, Mr. McDonald?
Your Honor, this is being offered for the truth of the matter. It is being used to demonstrate that Danny Emling placed rent in the mailbox on the night after the funeral. And I believe where this testimony will end is that Danny Emling could have touched the mailbox at that time, and therefore it is being offered for the truth of the matter.
I want to sustain the objection as to hearsay, but you're welcome to follow up with this witness as to the next steps she took in her investigative process.
Thank you. Emling left town immediately afterwards.
I believe so. That's what I heard from him.
And you knew that she thought Mr. Smith was a, quote, despicable person with little redeeming value. Her words, correct?
Objection, Your Honor. Hearsay again.
Response, please.
This is not offered for the truth of the matter. It is not offered to show that Mr. Smith was, in fact, a despicable person with little redeeming value, but rather to show that the officer did not conduct a thorough investigation.
Response, please, on behalf of the objecting party.
Your Honor, this is being offered for the truth of the matter. This is being offered to demonstrate Danny Emling's ill opinion of the victim, and will end in this line of questioning, attempting to paint Danny Emling as a potential suspect, and thus is being offered for the truth of the matter.
Your Honor, may I be heard?
Yes, certainly.
This is being offered as circumstantial evidence from which it may be reasonably inferred that Emling disliked the victim, and it is relevant to show that others may have had a motive to kill him.
I'll overrule the objection, allow the question to stand. Please ask it again and see if we can get a response from this witness.
Thank you. You knew Emling thought Mr. Smith was a, quote, despicable person with little redeeming value. Her words, correct?
I do not recall.
May I please refer the court to page 53, lines 8 through 10. You stated that Emling was, you heard when you were talking to Danny Emling that she said that Mr. Smith was a despicable person with little redeeming value. Is that correct?
Excuse me, could you repeat the page number?
Objection, Your Honor. This is calling for testimony that is outside of this witness's statement. You are being referred to Danny Emling's statement.
Your Honor, may I be heard?
Yes.
This witness has reasonable knowledge of all of the statements provided, as they did in fact collect the statements from the witnesses in this case.
I'll sustain the objection. We'll hear from Danny Emling regarding these issues. Thank you. Please continue.
Thank you. Knowing all of this about Emling, you eliminated her as a suspect. Is that correct?
I did. They had given me a thorough alibi.
But you made no effort to confirm that alibi. Is that correct?
Well, they did give me an alibi saying that they were out of town, so I thought that was suited enough.
Thank you. No further questions.
Thank you. Anything further of this witness, please?
Yes, just a brief redirection, Your Honor. May I proceed?
Go ahead.
Let's be clear, Ms. Garrett. How did you rule out Danny Emling in your investigation?
I interviewed them, and I had to determine they had an alibi for the day of Eric's death and the day of the snake bite, as they were out of town at the time. And they said they hadn't touched the mailbox on the night of the funeral.
After you determined their alibi, who was left as the only potential suspect?
Objection, Your Honor. That testimony contained hearsay.
It sure did. I thought we were going to hear from witness Emling regarding this, so I'll sustain and strike. Next question, please.
After you determined Emling's alibi, who was left as a potential suspect in this case?
Well, the defendant was the only suspect remaining, and with the evidence I had collected and them being the only person who approached the mailbox the morning before Eric's death, I concluded they likely murdered Eric Smith.
No further questions, Your Honor.
Thank you very much. Witness may be excused. Thank you. Next witness, please.
Your Honor, the prosecution calls Dr. Charlie Dunn to the stand. At this time, the prosecution requests a time check for direct examinations.
Prosecution has 2 minutes and 22 seconds left for direct and redirect examinations, and defense has 4 minutes and 9 seconds for cross-examination.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
For the convenience of the court, my name is Madison Alwell.
For the convenience of the court, my name is Evie McNulty.
Good evening, Dr. Dunn. Please state your name and qualifications.
My name is Dr. Charlie Dunn, and I have a bachelor's degree in biology. I graduated medical school, as well as completing a fellowship in forensic toxicology and a residency in clinical toxicology. Currently, I am chief medical examiner in Burnsley County.
Are you familiar with the snake that bit Eric Smith?
Yes, I am.
At this point, I would like to direct your attention to Exhibit D. Do you recognize this?
Yes, I do.
What do you recognize it as?
I recognize it as an image of the snake that bit and killed Eric Smith.
And is this an accurate representation of that snake?
Yes, it is.
Your Honor, at this time, I request that Exhibit D be moved into evidence.
Any objection?
None, Your Honor.
Thank you. D will be in evidence. Please proceed.
Thank you. What did you find peculiar when you looked at the snake in this picture?
The most peculiar thing would be that its rattle has been removed. And I also noted that its widest point is 2 inches.
Please describe your findings from the autopsy you conducted on Eric Smith.
I found 2 puncture wounds on Eric Smith's left wrist, which is consistent with a snake bite. And I also found acute tubular necrosis, which causes kidney failure, and epicardial hemorrhaging, which causes bleeding in the outer membrane.
1 minute.
And both of these conditions are consistent with a venomous snake bite.
Are you familiar with the statement made by herpetologist Tyler Clay?
Yes, I am.
And is it your opinion as a medical professional that there are any correlations between Eric's death and their past health conditions, as Tyler Clay says in their statement?
No, I think that Eric Smith died regardless of his previous health conditions, solely due to the snake bite.
30 seconds.
No further questions, Your Honor.
Thank you. Cross-examination, please.
Yes, Your Honor. For the convenience of the court, my name is Eleanor Attard. Dr. Dunn, in your 6 years as chief medical examiner for Burnsley County, you have only seen 3 deaths due to venomous bites. Is that correct?
Yes, that's true.
And in fact, only one of these has been bitten from a snake, yes?
Yes.
You state that very few people die of snake bites since they tend to seek medical help right away, yes?
Yes, I do.
So Eric Smith could have potentially survived if he had sought medical attention immediately?
Yes, that's true.
During the autopsy, you noted that Mr. Smith's kidney showed acute tubular necrosis, a symptom that can often lead to kidney failure, yes?
Yes.
This necrosis can be a product of a pre-existing condition or a direct result from the snake bite, yes?
Yes, although it's usually a direct result of the snake bite.
And this is also true of the epicardial hemorrhaging you found during the autopsy, correct?
Yes.
You stated in your testimony that snakebite toxins can exacerbate previous health conditions. Is that right?
Yes.
Thank you, Your Honor. No further questions.
Thank you. Any redirect of this witness?
Yes, Your Honor. As you previously mentioned in cross-examination, you said that the toxins from the snake venom can exacerbate previous health conditions. However, in this particular case, what is your opinion on that possibility?
I think that previous health conditions did not play a role in his death. I think that he died, again, solely due to the snake bite.
No further questions, Your Honor. May this witness be excused?
Absolutely. Thank you very much. Does that complete the witness testimony from the prosecution?
Yes, Your Honor. At this time, the prosecution rests.
Thank you very much. We'll turn the case over to the defense at this stage. Is the defense ready to proceed?
Pardon? Yes, Your Honor. At this time, the defense would like to call Jamie Kobe to the stand.
Thank you very much.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
Please proceed.
Yes, and for the convenience of the court, my name is Lawlette Edwards, and this witness's statement can be found on pages 42 through 46 of the case packet. May I begin?
Yes.
Are you currently employed?
No, I lost my job at the Blue Agave restaurant during the shutdown, and I couldn't find another job that didn't put my mom in danger of getting COVID or took me too far away from her. I do professional desert landscaping, but I haven't found a lot of work over the pandemic shutdown.
Did you know Eric Smith?
Yes, I live at 46603 Raptor Road, and Eric was my neighbor and my landlord.
What was your relationship with Mr. Smith like?
Not great. Eric sometimes wandered into my house as if he lived there, and he rarely fixed things when I asked him to. He kept blasting music at night, and even after I told him, it kept my mom awake. We had a lot of disagreements and called the police on each other several times.
Did your relationship change over the course of the shutdown?
Yes, our relationship got worse. With no job, I couldn't pay the rent in full. The eviction moratorium kept Eric from evicting us, so he tried to force us to move. He began randomly shutting off our electricity and water, and my mother used an oxygen machine to breathe, so that was a serious problem.
Directing you to April 22nd, 2020, did anything of significance occur that day?
Yes, on April 22nd, Eric shut off power again. I was outside and I couldn't hear my mom trying to call for help when her oxygen machine shut down. When I came inside, I saw her struggling and immediately took her to the hospital, but she died on the way there.
Did you confront Mr. Smith about her death?
No, but we did argue at my mother's funeral on April 28th. Eric was not invited, and when he asked me when I was moving out, I lost my temper and told him he killed my mother. I regret saying that.
Did you blame Mr. Smith for your mother's death?
Partially, yes. I was angry at him, but my mother had end-stage COPD. Her health was very fragile. She was already dying. I couldn't blame him for that.
What happened after your mother's funeral?
At 4 p.m., I went to Francis Yazzy's house to unwind, but I left after about an hour because I needed to be alone. So I gardened in the front yard until about 8 p.m. and vented my feelings yelling at garden pests.
What were you yelling?
Some of my plants had been ruined by rabbits and snails, and I think I shouted at them that I was going to kill them or something. I certainly didn't mean it. I tried to trap garden pests and release them into the wild, far away from my garden.
Did anything else happen?
Terry Edwards dropped by. I didn't really want to talk, so they left pretty quickly.
And did anything noteworthy happen the next day?
Yes, the next morning, I dropped off my rent in the top slot of Eric's mailbox. It was only $48 in cash, but it was all I could afford.
And were you carrying anything with you at that time?
Yes, I had my gardening tool bag and an empty wire humane animal trap with me. I was planning to sell the tools I didn't need to help cover the cost of my mom's funeral, so I had been collecting them when I remembered I needed to drop off my rent.
Jamie, did you have anything to do with Eric Smith's death?
No, of course not. I would never harm a living thing. Eric and I didn't like each other, but I would never actually try to hurt him.
Thank you. No further questions at this time.
Thank you. Cross-examination, please.
Yes, Your Honor. May I proceed?
Yes.
Good evening, Mr. Kobe. You spoke a lot about your troubles with employment recently. You currently work as a freelance xeriscaper, right?
Yes, I try to, but there isn't a lot of work with the pandemic.
Is that a yes?
Yes.
Which, of course, as you just stated, has not been financially successful for you, right?
Not entirely. People can't afford to pay for gardening right now.
Is that a yes?
Yes.
That has meant you are left to depend on your state unemployment and state disability checks that you get for your mom and yourself, correct?
Yes, those were my pretty much only sources of money.
Is that a yes?
Yes.
That has meant you aren't able to pay rent in full, correct?
No, not in full. I just tried to pay what I could, so Eric knew that we needed to live there.
Objection, Your Honor. Witness is being non-responsive. Motion to strike everything after the word yes.
Response regarding the non-responsive objection, please.
Your Honor, this witness has the right to explain their answers. He did answer the question and he was providing elaboration that was relevant.
Anything further regarding the motion to strike, please?
Yes, Your Honor. This witness is responding to the question and then launching into an overlong explanation that is not directly relevant to the question. If they would like to explain their answers, I ask that counsel redirect examine them at the end of this cross-examination.
As to this particular question and response, I'll respectfully disagree. The motion to strike is denied. The testimony will stand. Next question, please.
Now, this made your relationship with Eric rocky, right?
Yes, among other things that Eric did.
He attempted to illegally evict you?
He wanted to, but he couldn't because of the eviction moratorium.
That's right. And he started cutting off your power, yes?
Yes, during the hottest time of the year.
And that power was the only thing keeping your mother's life support machine running, right?
Yes, her oxygen machine was dependent on it.
Now, your mother would ultimately die during one of these power outages, yes?
Yes, she couldn't survive without her oxygen.
She died a week before Eric Smith did, yes?
Yes.
And at her funeral, Eric had arrived uninvited, right?
Yeah, I definitely did not want Eric there.
And you entered into a verbal argument at that time, yes?
Yes, entirely verbal.
Which, at that moment, yes or no, you directly blamed Eric Smith for your mother's death, correct?
I said that I blamed him, but I regretted it almost
Objection,
instantly.
Your Honor. Witness is being non-responsive. I have asked a yes or no question, and they have attempted to provide a non-yes or no answer.
I'll sustain and I'll grant the motion to
Your
strike after the word but.
Thank you. May I proceed?
Yes.
So, after the funeral, you left, right? Or excuse me, after the funeral, you returned home in the evening.
After I stopped at Francis Yazzi's house, yes.
Now, you mentioned you're a gardener, right?
Yes, I am.
And as a gardener in the desert, you have to be aware of potentially dangerous animals, correct?
Of course, for my own safety.
Including the Mojave rattlesnake.
Yes, that's a big one.
Which you know to be potentially dangerous.
Very dangerous, in fact.
A snake that you know requires special care if ever handled?
Yes, that's why I have anti-venom and the proper precautions at my house.
You mentioned anti-venom. Is that, excuse me, anti-venom, as you stated, is absolutely essential to survive a bite, right?
I consider it essential.
All right, thank you. The next morning, you approached the victim's mailbox, correct?
Yes, to drop off my rent.
You are aware that rent was not found in the victim's home, correct?
I'm aware, but I know that I put it in there.
Is that a yes?
Yes.
You were also carrying some gardening equipment, correct?
Yes, I left it in my front yard.
You were carrying a wire cage and a canvas bag.
Yes.
But you don't have all of that equipment in your possession today, correct?
Not all of it. I had to sell some of it in order to cover the cost of my mother's funeral.
So to be crystal clear, you sold a hunting knife, yes?
Yes.
Your snake cage, yes?
It was an animal cage, yes.
And your snake tongs, yes?
Yes.
Thank you. No further questions, Your Honor.
Any redirect of this witness, please?
Briefly, Your Honor. May I begin?
Yes, absolutely.
Mr. Kobe, did you blame Eric Smith for your mother's death?
Partially, yes, but I did know that she was very sick and old and her health was fragile. So I know it was the illness that killed her, not only Eric.
Thank you. No further questions. May this witness please be excused?
Yes, thank you very much.
Your Honor, at this time, the prosecution would like to request a time check for both direct and cross-examination if the defense would like it.
Defense has 10 minutes and 14 seconds left for direct and redirect examination, and prosecution has 6 minutes and 31 seconds left for cross-examination.
Thank you. Next witness, please.
Yes, Your Honor, the defense would like to call Francis Yazzie.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
Yes, I do.
Thank you.
Please proceed.
For the convenience of the court, my name is Zoe Wolfson, and this witness's statement can be found on pages 47 through 48. Ms. Yazzie, could you please introduce yourself to the court?
Of course. My name is Francis Yazzie. I've lived at 401 Raptor Road for over 10 years now, just about half a mile from Jamie Kobe and Eric Smith. I'm the former owner of the Blue Agave restaurant, which I was unfortunately forced to close because of the pandemic.
How do you know the defendant?
We've been good friends ever since Jamie moved here. Jamie worked with me at my restaurant. He taught me how to take care of desert plants, set up a drought-tolerant garden, and after the pandemic, we continued to see each other quite often. He comes over to my house, I would go over to his. He loves the green tea that I always have. And I used to visit him and Nancy, his mother.
How would you describe Jamie as a person, his character?
Jamie is a dear, even-tempered friend who was devoted to taking care of his mother. He's always been a patient, gentle, and a caring person, too.
What do you know about Mr. Smith?
I've known Eric Smith for years, and he wasn't well liked in town. He sold pot illegally to minors, and he had a reputation for being unkind. I wouldn't be surprised if someone else in town had something to do with his death.
Do you know what Eric and Jamie's relationship was like?
They did not get along. I was with Jamie on 2 occasions when Eric shut off the power to their house, and Jamie told me that Eric was trying to force Jamie to move.
Did you take any action?
Well, I first told Jamie that I thought it was illegal harassment for Eric to be doing that. I offered for Jamie's mom to move in with me, and then on multiple occasions, I personally asked Eric to stop turning off the electricity and explain Jamie's situation with Nancy, his mom, and her sickness.
How did Mr. Smith respond to your requests?
He didn't care. He refused to stop harassing Jamie and his mom, and he told me that he wanted his property back to build a big cannabis growing operation.
Objection, Your Honor, this testimony contains hearsay.
Response as to the hearsay objection?
Your Honor, this testimony is not going for the truth of the matter about whether or not he was actually going to build a big cannabis growing operation. It is just going to show both Eric Smith and Jamie Kobe's state of mind at that time.
Anything further regarding your objection?
Yes, can counsel elaborate on how Eric Smith potentially building a cannabis farm could relate to Jamie Kobe and Eric Smith's state of mind?
Well, that's a fine question, but that's really something I should probably ask. If indeed it's not being offered for the truth of the matter asserted, why is it relevant? Focusing on the goal of building a cannabis farm.
Absolutely, Your Honor. It's relevant because it goes to show what Jamie would feel. I mean, where Eric Smith wanted to put this cannabis growing operation was where Jamie was currently living. So it would affect Jamie's future. Thus, it would affect Jamie's relationship with Eric Smith, what he thought about Eric Smith, and his own plans for his mother and himself.
I appreciate the arguments of both counsel. I'm going to sustain the objection from a relevance perspective and strike the reference to the goal of building a cannabis farm. Please continue.
Yes, Your Honor, thank you. What happened on the day of the funeral?
Jamie came by my house at around 4 p.m.
Was that unusual?
Not at all. He often stopped by in the late afternoon if he wasn't gardening, once he was finished caring for his mother.
And how was Jamie behaving when he came over after the funeral?
Jamie expressed how hurt he was, and he seemed quiet. After we talked, though, Jamie was able to laugh about the absurd incident that took place at the funeral. Eric was just being Eric. And when Jamie left that night, he was back to his usual even-tempered self.
Thank you. No further questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. Good evening, Ms. Yazzie. You live on Raptor Road, correct?
I do, yes. Number 401 for over 10 years.
So that's a yes.
That is a yes.
And you live close to the defendant, right?
Yes, I live about half a mile away, so close, I would say.
And you and the defendant are good friends?
Absolutely, yes. We've spent a good deal of time together over the years we've known each other.
Is that a yes?
That is a yes, yes.
And you knew Eric Smith?
Yes, I did. I've known him for a similar amount of time.
Objection, Your Honor, the witness is being non-responsive.
Response as to that objection, please.
Yes, Your Honor. The witness for the past 3 questions has been saying yes or no, answering counsel's question, and then going on to elaborate based on their own experiences with the defendant, Jamie Kobe, and their relationship to both Eric Smith, Jamie Kobe, and other people in the neighborhood.
Anything further regarding the objection, please?
Yes, Your Honor, I'm asking a yes or no question, and no further statements are asked, and this is running time and in violation of Rule 3.8, subsection D. I would ask you to direct the witness to answer my questions appropriately.
I'm going to overrule the objection as to this question. This question and this response. I'll allow the response to stand, but I will direct the witness, listen to the question, provide an answer. If the question is calling for a yes or no, you provide that response. Next question, please.
Thank you, Your Honor. And you've visited the defendant's house repeatedly, correct?
Yes, I did. That is correct.
And Eric had a habit or custom of shutting off the defendant's power. Is that right?
Yes, he did. I experienced that.
And you personally saw this happen on 2 occasions. Is that right?
Yes, I did.
And the defendant told you that Eric turned off the power to get them to move.
That is what he told me. Yes.
And you're also familiar with Eric's reputation in town?
I am.
And Eric wasn't well liked in town, was he?
I would not say so, no.
And after witnessing Eric turn off the defendant's power, you told Eric to stop?
I did. I asked him to stop personally.
And however, he would always refuse.
He did, yes.
Now, on the 29th, Jamie, the defendant, spent time at your house after the funeral, correct?
Yes, he did. He came over afterwards.
And while there, they seemed agitated?
In the beginning, yes, they did.
However, an hour or so later, they went back to their even-tempered self. Is that correct?
That is what I experienced. Yes, their normal self.
So that is a yes?
That is a yes.
No further questions, Your Honor.
Thank you. Anything further of this witness, please?
No, Your Honor, may this witness please be excused.
Yes, thank you very much. Next witness, please.
The defense would like to call Danny Emling to the stand.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
At counsel's convenience, please.
Thank you, Your Honor. For the convenience of the court, my name is Eleanor Attard. And this witness's testimony can be found on page 52 to 53 of the case packet. Ms. Emling, could you please introduce yourself to the court?
Good evening. My name is Danny Emling. I own Emling Conveniences in town.
How do you know the defendant, Jamie?
We're neighbors. I live across from both Eric and Jamie on Raptor Road. Eric's my landlord, and Jamie did some fabulous work on my garden.
How would you describe Eric and Jamie's relationship?
The relationship was definitely rocky, but that's not saying much. Eric didn't seem to have a good relationship with any of his tenants.
And why do you say that?
I can recall plenty of arguments that I've gotten in with Eric over things such as rent and simple maintenance. On the rare occasion that I was late on my rent, Eric would shut off all of my utilities. And I know Jamie had some similar issues. Eric was blasting music really early in the morning one time, and Jamie just had to call the sheriff on him.
And how did Jamie react to these fights?
He would always apologize. He would get mad, but in the end, I think Jamie felt sorry for Eric, and I would always see him apologize.
Were you at Jamie's mother's funeral?
Yes, I was. Nancy was a really sweet lady, and I was sad to see her go.
Could you tell us what you witnessed?
There was an argument between the two. I remember Jamie yelling that Eric hadn't been invited and that he should leave.
Did you have access to Eric Smith's mailbox?
Yes, all of his tenants did. That's where we dropped off our rent.
And what were you doing during the time of Eric's death?
Immediately following the funeral, once I dropped my rent off in Eric's mailbox, I went to visit my family in a neighboring county.
Did you speak to Deputy Garrett about Eric Smith's death?
Yes, while I was away, I got a call from the deputy informing me about Eric's death and asking me about my fingerprints on the mailbox, to which I explained.
Did you like Eric Smith?
No, frankly, I think he was a despicable person with little redeeming values.
Did you tell the police that when you were interviewed?
Yes, I did.
Thank you, Your Honor. No further questions at this time.
Cross-examination, please.
Yes, before I begin cross-examination, the prosecution requests a time check on cross-examinations.
Prosecution has 4 minutes and 45 seconds left for cross-examination.
Thank you. You know the defendant, correct?
Correct. He's my neighbor.
You are friends with the defendant.
Yes, I would say so.
You also knew Mr. Smith?
Yes, he was my landlord.
You rented from Mr. Smith, correct?
Correct.
You paid rent,
Yes, I did pay rent.
but you'd be late to some payments?
Yes, that was very rare, but every once in a while I would be late.
So you would be late to some payments.
Yes, to some.
You did not get along well with Mr. Smith, correct?
No, but who would? He was sort of a pain and no one really got along well with him.
He would shut off your power?
Yes, very rarely when I was late on my rent, which once again was very uncommon.
Objection, Your Honor, this witness is being non-responsive. I asked a yes or no question. They responded with yes and then provided irrelevant testimony afterwards.
So your objection is non-responsive and irrelevant?
Yes.
Response, please.
Your Honor, this witness provided an answer and is simply elaborating on their answer.
Your Honor, may I be heard?
Yes.
This witness has provided many elaborations after their answers. I'd like to once again direct you to the Mock Trial Rules and Regulations 3.8 subsection D, titled Running Time. If they would like to expand upon their answers, I would suggest them to do it on a redirect examination.
Here's what we're going to do. I will overrule the objection, allow the response, but I'll direct the witness that if indeed the question calls for a yes or no, please respond yes or no. Next question, please.
Thank you, Your Honor. He would also shut off your water, correct?
Correct.
You're not fond of Eric, are you?
No, I'm not fond of him.
You thought Eric was a terrible person.
Yes, I mean, who shuts off the power knowing that a resident
Objection, Your Honor.
is
This witness
dependent?
is also being non-responsive here.
I'll sustain. That is non-responsive, and I'll respectfully strike. Next question, please.
I want to talk about the fight at the funeral now. In the weeks before the death of Jamie's mother, you witnessed Jamie and Eric arguing, correct?
That is correct, yes.
After the death of Jamie's mother, did you attend her funeral?
Yes, like I said previously, I attended.
After the death of Jamie's mother, you witnessed Mr. Smith come in, correct?
Yes, correct.
He was not invited?
Not that I know of.
He was not invited?
No.
This made the defendant mad?
Yes, the defendant was mad. It was his mother's funeral.
Objection,
He was-
Your Honor. This witness is also being non-responsive.
No, I'll allow that answer. Next question, please.
Did you witness a fight between Jamie and Eric while you were there?
Yes, I did witness a fight.
And do you believe that Eric Smith killed Jamie's mother?
Yes, I mean, he shut off the oxygen, the power.
Objection, Your Honor. This
knowing-
witness is being non-responsive. I asked,
No,
I
I
you
heard the
believe...
question. You don't have to repeat it. I heard the question. She responded yes. I'll respectfully agree with counsel and strike the further response. There wasn't a complete response, but at least the attempt to offer a further response. Answer of yes will stand. Next question, please.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination, please.
No redirect, Your Honor.
Oh, I'm sorry, redirect. Thank you very much. No redirect at this point, so this witness may be excused.
Thank you, Your Honor.
Thank you. Next witness, please.
Yes, Your Honor, the defense would like to call Dr. Tyler Clay.
Your Honor, at this time, the prosecution would like to request a time check on cross-examination and direct examination for the defense if possible.
Defense has 5 minutes and 16 seconds left for direct and redirect examination, and prosecution has 2 minutes and 58 seconds left for cross-examination.
Thank you.
Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will truthfully and faithfully conform to the facts and rules of the mock trial competition?
I do.
Thank you.
May I begin?
Yes, thank you.
For the convenience of the court, my name is Zoe Wolfson, and this witness's statement can be found on pages 49 through 51. Could you please introduce yourself and state your qualifications to the court?
I'm a herpetologist. I have a Bachelor of Sciences degree in biology, as well as a master's and PhD in biology with a specialization in herpetology from Central State University in California. I have written and published a book titled The Snake Whisperer: Life Among the Snakes, and I've had several careers as a resident naturalist in state parks. Currently, I'm the director of the Southland Zoological Museum.
What have you done to prepare for your testimony?
I've reviewed the medical examiner's report as well as examined the Mojave rattlesnake specimen, which bit Eric Smith. I also reviewed witness statements.
Based on your research, are rattlesnake bite deaths common?
No, not at all. Because antivenom is widely available, the Mojave rattlesnake bite rarely kills a human being.
Why would someone die from a rattlesnake bite then?
People often don't realize how serious it is. It can take hours for symptoms such as loss of vision, muscle spasms, difficulty breathing, which can ultimately result in cardiac arrest, to result. Because serious symptoms do not manifest immediately, people can wait too long before getting help. The antivenom must be administered promptly after the bite.
Do you agree with Dr. Dunn's conclusions regarding the bite?
I agree that the wound on Eric Smith's wrist was indeed caused by a Mojave rattlesnake.
And is the missing rattle abnormal?
No, it's a natural occurrence, common to all species of rattlesnake. Adult snakes shed their skin twice a year, and even more frequently in juveniles. They can scrape against rocks and other objects to try and pull the skin off, and sometimes their rattle can come off as well. You know, rattles are made of the same material that our fingernails are made of, keratin, so they're actually quite fragile. Missing a rattle is a very common pattern for rattlesnakes.
What do you know about Mojave rattlesnakes' behavioral patterns?
They're most active in California between April and October, and they aren't considered overly aggressive except when disturbed. Snakes enjoy hiding out during the day to stay out of the sun and wait for prey. They're experts at squeezing into a multitude of places like barbecue appliances, under stacked wood piles, under car hoods, and mailboxes. Most people living in desert ecosystems are very careful when opening any enclosed space, like a mailbox.
How do snakes react when found in mailboxes?
When someone reaches into their mailbox, the snake's natural reaction is to bite defensively.
Have you reviewed Exhibit B, Mr. Smith's mailbox?
Yes, I'm familiar with the photograph, as well as the deputy's description of the dimensions of the mail slot on top.
In your professional opinion, could the snake have crawled into the mailbox through the slot in the top?
Yes. I mean, it could have crawled in through the front mailbox door if it were open, or it could have crawled in through the top slot of the mailbox. See, snakes have connective tissue in between.
Objection, Your Honor, unfair extrapolation.
Response as to unfair extrapolation?
Your Honor, may I clarify exactly what I'm referring to before?
Please.
The statement connective tissue is not found within the fact situation of this case and is therefore unable to be testified to. Furthermore, it is an unfair extrapolation because it will materially affect the outcome of this case, as it demonstrates potentially with greater ease how a snake could enter that mailbox. Therefore, it may not be included in this testimony.
Response, please, as to the objection of unfair extrapolation.
Yes, Your Honor. What this expert has testified to doesn't alter material facts. It just elaborates on whether or not the snake could fit, something the expert has already testified to. Furthermore, they are an expert in this field and would logically know about whether or not the snake has connective tissue that can expand and contract.
Anything further regarding your objection, please?
Yes, Your Honor. First, this is a material fact, as it is being used on top of the statements within this expert's statement that say that the snake could have climbed inside to imply that it may have been easier to slide inside and thus affects the outcome in this case. Further, regardless of this witness's status as an expert, they cannot testify to anything that is beyond the scope of the mock trial fact situation, as this testimony is.
Where is the phrase connective tissue within the statement of Dr. Clay, please?
Bring you to page 51, lines 9 through 10, although it does not directly say the connective tissue, it does say, pardon me, Your Honor.
Finding and squeezing into hiding places.
Yes.
I'll overrule the objection. I'll find it's a fair extrapolation. Please continue.
Did you get a chance to finish your answer?
No, I did not. The connective tissue between the scales of a snake are able to expand and contract. You've all seen pictures of snakes with large lumps in their middle, and that's because their skin has expanded to accommodate whatever large creature they have eaten.
So would a snake have difficulty climbing up and into the mailbox?
No, not at all. Because of the rough texture of the wooden post to which the mailbox was attached, it would be easy for the snake to climb up and into the mail slot.
Thank you. No further questions.
Cross-examination, please.
Yes, Your Honor. Excuse me. May I proceed?
Yes, thank you.
Good evening, Dr. Clay. Let's be crystal clear. You are not a medical expert, right?
No, I am not. However, I do have a PhD in biology.
You have never been to medical school?
No, I have not.
You did not conduct the autopsy in this case.
No, but I thoroughly reviewed the medical examiner's report of the autopsy.
Is that a no?
Yeah, I said no.
Thank you. And your determination on the death of Eric Smith differs from that of Dr. Charlie Dunn, who is a medical expert and who is the one who conducted the autopsy. Yes or no?
Yes, I said that but I am not a medical expert as stated. The cause of death is not.
Objection, Your Honor. Witness is being non-responsive and attempting to expand on a yes or no answer.
Response from opposing counsel, please.
Yes, Your Honor. This is an expert witness. Therefore, they are qualified to give their expert opinion on things, and they should be allowed to expand on their answer because of their expertise, which they can offer to the case.
Anything
Your Honor,
further
may I-
regarding your objection of the response not being responsive?
Yes, Your Honor. I have phrased this as a yes or no answer. This witness has yet again answered yes and expanded onto irrelevant testimony with respect to the question. I ask that you sustain this objection.
I'll sustain the objection and strike the balance of the response. Again, it can be followed up on and redirect if counsel deem it appropriate. Next question, please.
You are, however, an expert in snakes, right?
Yes, I am.
And you've identified the snake in today's case as a Mojave rattlesnake, right?
Yes, I have.
Which is one of the most venomous snakes in North America.
Yes, it is.
And it has a venom that you stated doesn't show symptoms until potentially after the bite.
Yes.
And that means that a victim of a bite may not actually seek
2 minutes.
even if they need to.
Sorry, could you repeat that question?
Yes, it means that a victim who has been bitten by the snake may not seek medical attention even if they need to.
Yes, that is true. However, yes, that is true.
Now, if someone was to handle these snakes, you believe it should be done with caution, yes?
Yes, handling a rattler without the proper materials would be incredibly dangerous.
Is that a yes?
Yes.
Thank you. You believe this should be done with a certain set of tools to ensure your safety,
Yes, that is true.
including some form of cage to handle the snake?
Yes, and people who live in the desert
Objection, Your Honor. Witness is being non-responsive, attempting to expand on a yes or no answer.
Anything further from counsel who called this witness in relationship to that objection, please?
Your Honor, just to reiterate, the expert has lived in the desert for a number of years. That gives some unique perspective as to whether or not people would need a rattler trap, a cage, any other materials. And being an expert, they are allowed to elaborate on their answers and explain their reasoning.
Your Honor, may I be heard?
No, it's not necessary. I'll sustain the objection and strike after the word however, but again, it can be followed up on in redirect if counsel deem it appropriate. Please continue.
Thank you, Your Honor. Despite these factors, you still state that it is unlikely to die from a Mojave rattlesnake bite, right?
Yes, because antivenom is widely available. And
However,
effective.
just to be clear, the victim did not take antivenom, right?
Yes,
1 minute.
which is why the victim died.
And you believe that is contravention of standard medical advice, yes?
Yes.
Thank you. No further questions.
Anything further of this witness, please?
Briefly, Your Honor. To be clear, why did the victim die?
The victim died because they did not seek medical attention. Antivenom must be administered promptly after the bite to be effective.
Thank you. No further questions, Your Honor. May this witness please be excused.
Yes, thank you very much. Anything further on behalf of the defense at this point?
Nothing, Your Honor, and at this time, the defense rests.
Thank you very much.
Oh, and the defense asks that Exhibit B be admitted into evidence. I believe that's already been covered. Is that correct?
It may have already been moved into evidence, but any objection to B being in evidence?
Your Honor, to be clear, B has been moved into evidence already. There are no objections. Thank you.
So noted.
Okay, thank you.
So the defense rests at this point, and we'll proceed with closing arguments in light of the completion of evidence. Is the prosecution ready to proceed with its closing argument?
Yes, Your Honor. May I proceed?
Absolutely.
The defendant is angry. Eric Smith has done nothing but harass and humiliate them for years on end. But this time, he has gone too far. This time, the defendant believes that Eric Smith has killed their mother, and now they want nothing short of revenge. So they'll use the one thing they know best: nature. That is the story of the trial here tonight. But as the defense will likely remind you in just a brief moment, a story is not good enough to convict the defendant. No, we, the people, hold the burden of proof. We must demonstrate that the defendant is responsible for the death of Eric Smith, and that in pursuing that action, the defendant acted willfully, deliberately, and with premeditation, and thus satisfied the three elements of first-degree murder. We will do this by asking and answering two simple questions about the trial tonight: why and how. Let's start with why. Why would the defendant murder Eric Smith? Why was that snake in the mailbox? Well, it's relatively simple. The defendant and Eric Smith had a long history of conflict from before the pandemic even began. Deputy Sheriff Tony Garrett testified that they responded to half a dozen or more calls from one or the other over the course of several years. It only got worse with the pandemic. As the defendant admitted themselves, they couldn't pay rent in full. So Eric started doing what Eric does and has done to Danny Emily, cutting their power. In fact, the defendant's own best friend, Francis Yazzie, watched it happen twice with their own eyes. Ultimately, this would prove to be the final straw, as during one of these power outages, the defendant's mother died. About a week later, and just a day before the murder of Eric Smith, the defendant could be seen and heard angrily screaming and blaming the victim for their mother's death. That is why the defendant would kill Eric Smith. Now let's move to how. How did the defendant murder Eric Smith? How did the snake get in the mailbox? Well, that will be the most crucial question of the trial here tonight. And the defense and Dr. Tyler Clay contend that they have provided a more than reasonable explanation for why that snake was in the mailbox. It climbed up there of its own volition. There's just three problems with that. First, the mailbox was more difficult to access as it was elevated multiple feet off the ground. Even for a snake, that elevation makes it a less enticing target. Second, it was an even less enticing target because it had the same temperature as the exterior and would have been well lit thanks to the 6-inch slot on the top. Snakes go hide in shady and cool places to escape the heat and sun. They would not hide in a warm and well-lit mailbox. Finally, even if the snake had gotten inside, it could not have fit in. If the mailbox door was closed, the snake was 2 inches across, whereas the slot on top was 1 3/4 inches. There is simply no reasonable explanation for the snake seeking out and entering that mailbox without human help. And that is where the defendant comes in. You see, the defendant knew that the snake was prevalent in Burns County. The defendant knew that it was potentially deadly. But most importantly of all, the defendant knew that Eric Smith likely would ignore medical advice. So they had their evidence and they had their plan. All that was left was to put it into motion. The defendant returned home after the funeral to Garden, where they interacted with Terry Edwards, talking about something important, something big they had to do before they went to sleep. This was it: catch a snake. The next morning, they took it into their back garden and cut off its rattle and left it there to be captured on Exhibit A, the victim's own security camera. The defendant left their house that morning, carrying a snake in a cage, a canvas bag full of tools, and revenge on their mind. Angel Russell watched them approach, the only person to do so beside the victim that morning, glancing nervously down at this cage because the defendant had a snake in it. Then Angel Russell turned away and left the defendant with practically infinite time alone to place that snake inside. Even in the moment that would prove to be his death, Jamie Kobe knew who had struck him. It was Eric Smith knew who had struck him. All that was left for the defendant to do was to hide their evidence. So they sold their equipment. They sold a hunting knife that they used to cut off its rattle, their snake cage, and their snake tongs, spreading everything to the wind. That is how the defendant murdered Eric.
2 minutes.
But the answers to these questions must align with someone acting willfully, deliberately, and with premeditation. So let's analyze each of those individually. Someone acts deliberately if they weigh the consequences of their actions and choose their methods appropriately. Like I said, the defendant knew they could catch one of these snakes. The defendant knew that the snake was potentially deadly. And the defendant knew that Eric Smith was very vulnerable to it, as they had pre-existing conditions. They chose their methods appropriately and acted deliberately. Someone acts willfully if they intend to kill, and with premeditation if they decide that fact in advance of committing the act. Let's listen to the defendant's own statements as heard by Terry Edwards just a day before Eric Smith's murder. This is it. I am finally going to do it. I am going to kill him. Make no mistake, Your Honor. The defendant wanted Eric Smith dead and decided that fact well in advance.
1 minute.
Your Honor, there is no doubt left in this case. The defense will present alternating theories about a snake entering a mailbox of its own volition, and perhaps even postulate on Danny Emling being a suspect and a biased investigation. However, these are smoke and mirrors, and you must see through them. Listen to the facts. The defendant wanted Eric dead and chose their methods appropriately. Therefore,
30 seconds.
They must be found guilty. Thank you.
Thank you. Is the defense ready to proceed with its closing argument?
Yes, Your Honor. May I begin?
At your convenience. Thank you.
We are here not to weave stories of what might have happened, but to determine what we know and what we do not. This is what we know beyond a reasonable doubt. A Mojave rattlesnake can get into a mailbox by itself. Dr. Clay, a published expert in herpetology, testified that this 2-foot-long, 2-inch-wide snake could easily have climbed up the rough wooden post and squeezed through the mail slot. Rattlesnakes are regularly seen in Bernsley County, and it's common knowledge that snakes seek out small spaces to hide in. The composition of their skin allows them to fit into these small crevices. Rattlesnakes shed their skins twice a year and frequently scrape off their rattles in the process. This is a natural occurrence common to all rattlesnakes. This is what we know. Jamie Kobe spends much of his time working outside in rattlesnake habitat. He owns snake handling gear for his own safety. This is what we know. Jamie and Smith did not have a good relationship, but their disagreements were petty and childish, never violent. On April 22nd, Mr. Smith shut off the power to Jamie's house, and Jamie's mother's oxygen machine stopped working. She died on the way to the hospital. Jamie was devastated, and he was angry at Smith for triggering his mother's death and at himself for keeping her with him, though she would have been safer at Yazie's house, and for working in the garden as she struggled, too far away to hear her cries. But he could not truly blame Smith because he knew his mother was dying. At any moment, she could be gone. Jamie was at Smith's mailbox on the morning of April 29th. He was dropping off his rent money in the slot, $48 in cash. Jamie had gathered up the cage and other tools because he had decided to sell them to help pay funeral bills. And nothing Angel Russell saw contradicts this. He did not see anything in the cage. Jamie was wearing no protective equipment, and he did not see Jamie remove anything from the cage or the bag, and did not see Jamie open the mailbox or put anything inside. Deputy Garrett testified that she did not find Jamie's envelope in Smith's home, only 3 envelopes containing checks. Cash doesn't need to be taken to the bank, just pocketed. And the deputy never looked for cash. The state argues that only Jamie had a motive, but we don't know that. Though Deputy Garrett knew that Smith was detested in the community, she didn't follow up on any other leads. Emling was Smith's tenant too. Emling had many of the same problems with Smith that Jamie did, and this was Emling who called Smith a terrible, despicable person with little redeeming value. These are strong words. Emling's fingerprints were on the mailbox too, and she left town immediately after dropping off the rent in the same mailbox. But Garrett interviewed her and decided that she was not a suspect. Emling said she had an alibi that Garrett never confirmed. This is a reasonable doubt. Deputy Garrett's investigation was biased from the beginning. She set about selectively gathering only the information that confirmed
2
her
minutes.
suspicion. This was not a thorough or impartial investigation. This failure creates reasonable doubt. As for the testimony of Terry Edwards, it should be viewed with caution. No one else can corroborate almost any of Edwards' claims. He admitted in cross-examination that he didn't like Jamie. And if Edwards is to be believed, Jamie spent his mother's funeral reception telling guests that he was finally going to do something. Of course, Edwards didn't hear what. And when he misheard Jamie's "I'm going to kill them" regarding the pests in his yard as "I'm going to kill him," if that is what he heard, he did not alert the police or warn his friend Smith. Whatever Edwards thinks he heard, he did not view it as a threat. The prosecution's story
1
is
minute.
just that, a story. And as the prosecution weaves its tale, they ignore crucial details that don't fit their narrative. Details that cannot be ignored because they create a reasonable doubt. When Jamie's mother died, he was devastated. He was not seeking revenge. He was grieving. The prosecution has not only failed to prove beyond a reasonable doubt that Jamie
30
committed a
seconds.
crime, they have failed to prove that a crime was committed at all. The only just verdict on both counts is not guilty. Thank you.
Thank you very much. Any rebuttal from the prosecution?
Yes, Your Honor. May I proceed?
Yes.
The defense is sticking to what we know. So let's analyze each of their theories with what we know beyond a reasonable doubt. First, the snake entering the mailbox completely of its own volition. We know beyond a reasonable doubt, as it is stipulated today, that the mailbox was the same temperature as the exterior, and that it had a long slot on top, which would have illuminated that space. It was not an enticing place for a snake to be. Therefore, it is unreasonable to assume a snake would have entered that mailbox of its own volition. Second, they claim that Danny Emling should have been a suspect, and Tony Garrett didn't pursue them because they were out to get the defendant.
30
This
seconds.
is even weaker. We know beyond a reasonable doubt that Danny Emling left town the day before the snake bite and provided an alibi. Danny Emling could not have committed this murder, and Deputy Garrett was right to rule them out. There is no doubt in this case. The defense has failed to provide a reasonable alternative theory of the case, and instead has opted for fanciful notions of a snake entering a hot and well-lit mailbox in order to escape the heat and sun, and a biased investigation that was out to frame the defendant. Don't be distracted.
Stop.
Find them guilty.
Thank you. Any rebuttal from the defense?
Yes, Your Honor. May I begin?
Yes, please.
Jamie did place some blame on Smith for his mother's death, but he knew it was her illness that killed her. The rattlesnake, not its skull, was 2 inches wide. Dr. Clay, a published expert in herpetology, has testified that this snake's behavior in getting into the mailbox by itself was consistent with snake behavior that they have seen before. The only just verdict is not guilty.
Thank you very much. Before I offer a verdict, students may confer with their attorney or teacher coaches regarding any trial irregularities. If you would please do that now.
Your Honor, the prosecution has no irregularities to report.
Thank you very much.
And the defense also has no irregularities to report.
Thank you very much.
Thank you, Your Honor.
I will find the defendant guilty of a violation of Penal Code Section 187. And at this point, I will congratulate all of you in terms of your efforts in this matter. I was extremely impressed with all of you, and I can see why these are the two teams that ended up in the finals of this extremely competitive competition. I congratulate the teachers and the attorney coaches. A wonderful job by all of them in relationship to the teams that I saw to date. Congratulations to all of the members of each team. Again, it's easy to see why you folks are in the finals. There were no weak links with anyone, whether it was attorney, witness, clerk, bailiff, whatever the case may be. Everyone did an outstanding job. I will just briefly say, excellent effort by the two pretrial attorneys. That is a difficult position to be in this competition. It is stressful, and I felt that both of the attorneys, both Ms. Fong and Ms. Murray, responded clearly and directly to the court's questions, were extremely thorough with their responses, and then were able to seamlessly get back to their arguments. And I was very impressed with both of you. Thank you very much for allowing me to watch you this evening. I will now go to the scoring attorneys for some short comments. They're somewhat constrained in terms of how long they can offer comments in light of the fact that they need to get their results for final tabulation. But I'll inquire, first of all, Ms. Mattison, is there anything that you'd like to offer to these teams?
Thank you, Your Honor. Yes, I would like to echo the judge's comments and congratulate both teams. I think this was a superb academic competition between two extremely well-matched teams. I enjoyed every single minute of tonight. I think every single one of you performed to your best. And I just congratulate all of you and thank all of the teachers, all of the coaches, all of the students, and yes, your families too, because that's where your support comes from, for participating in this just really well done mock trial competition. Thank you.
Thank you, Ms. Mattison. Mr. Forbes Roberts, any comments, please?
Yes, thank you, Judge, and thank you. It's a privilege to be part of this competition, and in the way that we were able to do, to watch the so much hard work and so much preparation, so much the composed demeanor of each of you is just so impressive. As someone who has practiced in Judge Volkman's court, it can be very intimidating. It can be, when he's asking the questions, to bring out the evidence, the facts. But every one of you in the pre-trial motions, responding to objections and his rulings, so respectful, but also exhibiting such a great knowledge and understanding of the law at a level. You guys just it's just an honor to be able to watch this competition and see all this hard work. I like the judge said, we're a little constrained in the times. I don't know whether or not either of these teams is going on into states or what's the next step. But, I think that there is a means where we can provide some individual suggestions if that's warranted or desired. Thank you so much. Great job. thank you to all the parents, all the coaches, all the the people that volunteer, but mostly to you students for all the hard work. No matter how you proceed in life, this is a good step. So thank you.
Thank you, sir. Mr. Mendeville, any comments, please?
Sure. I've been doing this now for 12 years, and these two teams are the reason that I enjoy doing this. It was an amazing way to spend an evening watching these two well-prepared, well-polished, and amazing teams present. And I just want to say thank you to all of them and everyone who helped get them to this point. Thank you, Your Honor.
Thank you, sir. And Mr. Mohammed.
Yes, thank you, Your Honor. Fantastic job from everyone on both teams. I also have scored a mock trial for many years and participated in this county when I was a teenager. Real quickly, it was too close to call in my view, so the scores are going to be what they are. Whichever team goes on, I would just say focus on the small details that might get you a point one way or another. And I specifically want to point out the gambit that was played with equating the witness's testimony to the knowledge of the police officer. I really like that. I really like the way that the other side handled it. It was sort of, so that was really good. And I would say that if that's the team that goes on, or if you're going to try something like that, make sure you have your gambit dialed in. Say, hey, you impeach them with the testimony, go through it, and don't back down on it. But that's the type of thing that you need to do to stand out when both teams are so well prepared. On the other side, the constantly asking motions to strike and objecting to non-responsive, controlling the time, it was really good, and it anticipates the tendency for the witnesses to say yes, and because of this other 7 things, and waste your time. It also can become a little bit by rote, so be careful with that. Really let the witness drag it out. Don't just keep doing it each time. So both of those things. Also, I don't know if whichever team goes on to state, if it's going to be on Zoom, get a unique uniform background for everybody, whichever team it is. And just focus on those little details. Those are the things. Every team at state is going to be super well prepared, and they're going to be flawless. So you got to find little ways to distinguish yourself. Congratulations to everybody, and good luck.
Thank you very much, Mr. Mohammed. Again, I agree with all the scoring attorneys and their comments. I was extremely impressed with both teams. And this is challenging to do under this format. I'm very disappointed that we couldn't have it live and couldn't have it in a courtroom. I'm really hopeful that we'll be able to do it in that format next year. It's much more challenging for the attorneys and the witnesses to make their presentations when you're somewhat making that presentation in a vacuum, rather than having the energy of a live courtroom with people in the audience and folks going back and forth on examination and response. So the fact that you folks did so well in this limited format is another basis upon which I was impressed this evening. I wish both teams nothing but great success in the future. Thank you very much. It's my understanding that the scoring attorney is going to provide the scores at this point. They're going to be tabulated. We're going to get together a little bit later on in the evening for the results. Again, congratulations, and I appreciate the efforts of all of you folks. Thank you very much.